Court does call the case of the people versus Kevin. Is it Navajas Vargas?
This opening ruling sets the tone for the entire morning. Defense asked for time, mentioned bond modification discussions, and emphasized that everything is a surprise. That phrase is subtle but strategic. It suggests either late disclosure, unexpected developments, or negotiation friction. Judge Simpson's response is controlled and procedural. Adjournment granted, bond unchanged. That matters. When a judge keeps bond intact, it signals no immediate shift in risk assessment. No escalation, no reduction, stability. A probable cause conference is often where plea talks intensify. It's not a trial, but it's a checkpoint. By pushing this to May 1st, the court gives both sides time to negotiate, but not unlimited time. Here's what's happening beneath the surface. Defense wants flexibility. Prosecution isn't ready to concede. A judge maintains structure. Would you read this as a defense buying time to improve leverage, or prosecution holding firm on terms? Because in pretrial stages, time itself becomes a bargaining chip.
Your name, sir?
Kevin Vargas. Good morning, Your Honor. Thank you, Kevin.
I apologize, Your Honor. Lord Yagis, with and on behalf of Mr. Barajas Vargas, I apologize. I was under the courtroom. In this matter, I would be asking for an adjournment. We requested, well, we're in discussion. I requested bond modification if people were not able to agree to it at this time. But I would like some additional time to go over discovery and discuss the resolution.
Because everything is a surprise. All right. Probable cause conference without objection will be adjourned May 1st, 2025, 9 a.m. Bond will continue at this time. I need a green sheet, please. Court calls the case of the people versus Kurt Burke.
And then on behalf of Your Honor.
Good morning, Your Honor. Dan here on behalf of Kurt Burke. One of them is bodies, on the other.
Not off to the start today, Your Honor. I apologize. Lord Yagis, public center. I swear. With on behalf of Mr. Burke in the second.
All right.
Kurt Burke.
Your name, sir?
Kurt Burke.
Thank you.
Your Honor, we're asking for a preliminary examination dates on both matters.
Is that correct, Ms. Yagan?
Yes, Your Honor. And just for the record, Mr. Guerin has prepared a substitution of counsel, which I signed this morning for the second matter.
Okay, so you'll be substituting in on the other.
No, those are that on the record. So,
actually, if the form is here, I'll sign off on it. And then, all discovery is complete.
I believe it is, Your Honor.
And would the people have their witnesses available the 29th?
We'll do our best, Your Honor.
Preliminary examination in person will be set April 29th, 2025, 9 a.m. before Judge Barr.
Now we move into Kurt Burke's case, and this is textbook felony procedure. Defense requests a preliminary examination. That is not casual. A prelim forces the prosecution to present witnesses and show probable cause under oath. Notice how smoothly this is handled. Substitution of counsel acknowledged, discovery believed complete, witness availability confirmed. This is structured preparation. No surprise objections, no chaos. When discovery is complete and prelim is scheduled, both sides are essentially saying we're ready to test the strength of the case. Bond continuing again tells us the court sees no new risk. Judge Simpson is consistent. Stability unless there's a reason to intervene. Preliminary exams can shift power. Defense gets to cross-examine early. Witnesses get locked into testimony. Inconsistent statements later can be exposed. If you were defense counsel, would you aggressively cross at prelim to expose weaknesses, or hold back to avoid revealing your strategy? Because every early question asked is information the prosecution can later prepare for.
All right. Bond will continue. Thank you. Court does call the case, people versus Michael Collison.
As elected people.
Assistant Public Defender Shelby Fairfield, Commissioner Confidential Collison, Collison,
Good morning, Dr. Collins.
Remember, we provided with report and the police report in this case, you'd like to put no contest.
And I have an advice of rights.
Yes, Your Honor, the plea form, reports will have to indicate a plea to an added count of largely 200,000, an added count of use of methamphetamine agrees not to have possession of methamphetamine from this incident. And a dismissal of the original count of, I'm sorry, I don't have it in front of me.
Count 1
Yes, count 1.
would be dismissed. He's going to plead no contest to counts 2 and 3. Both 1-year misdemeanors, one larceny, 200 to 1,000, the other use of methamphetamine upon a successful plea. Count 1 would be dismissed, and people have agreed not to charge or add the possession of methamphetamine from this incident.
Thank you, Your Honor.
Is that a correct statement of the agreement?
Yes, Your Honor. There is a signed advice of rights form to.
Seven sworn.
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and yes. State your name. Michael Scott Allen.
All right, sir, this court's understanding that you're going to be pleading no contest to 2 charges. Is that your understanding? The first charge being the added count 2 of larceny, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
That's Your Honor.
The other is the added count 3 of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand all of that?
Yes, Your Honor.
Do you understand what a no contest plea is? All right, 2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
This is one of the most important educational moments in the hearing. Judge Simpson carefully explains what no contest really means. Many defendants think it's softer than guilty. Legally, for sentencing, it is not. The judge emphasizes 2 things. You are giving up your right to contest the charges, and you will be treated the same as if you pled guilty. That eliminates ambiguity. Why does no contest exist? Often to avoid admissions that could affect civil liability. For example, if there were related lawsuits. But criminally, the consequences are identical for sentencing. The court also ensures voluntariness, no coercion, no promises beyond record, no threats. That record protects the plea from later appeal. This is procedural precision. Judges go line by line because a flawed plea colloquy can overturn a conviction. If you were in this defendant's position, would clarity about maximum penalties make you hesitate, or does certainty reduce anxiety compared to risking trial?
You understand also that, sir, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
Okay, understanding all of that, you still wish to plead no contest.
Yes.
Basis for the no contest plea? All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of use of methamphetamine, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
That's correct.
All right. You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of rent.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
That's correct.
All right. Court has been provided and has reviewed Ann Arbor Police Department reports for their case number 25-10459. Actually, 2 reports I reviewed. Counsel, any objections to the court having reviewed those reports?
No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
You are satisfied?
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed.
This is the formal acceptance point. The judge references reviewing Ann Arbor Police Department reports and explicitly states there is sufficient factual basis. That phrase matters. Courts cannot accept a plea without establishing that facts support the elements of the crime. The defense confirms satisfaction. The prosecutor confirms no objection. The record is clean. Then comes pre-sentence investigation and a future sentencing date. That gap between plea and sentencing is strategic space. Defendants often begin treatment, employment, or restitution efforts during that time to improve sentencing posture. The tether discussion reinforces supervision. Release tied to treatment isn't unconditional. The court is signaling rehabilitation is possible, but monitored. This is where criminal court transitions from adjudication to consequence planning. The conviction is locked. Now mitigation begins. In your view, should early cooperation and treatment enrollment significantly reduce sentencing, or should the offense itself dominate the outcome?
Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 20th, 2025, 9 a.m. before Judge Vallow.
Is it possible to get any later sentencing date? He's working out of this inpatient treatment right now, so he's probably will be in inpatient treatment at that time.
You can certainly arrange that with Judge Vallow's office. That is the date that we have. Okay. You see, okay, there's a stipulation for release of treatment, which I've signed.
Yes, sir.
And also we signed a community corrections location tracking tether. So that he would have to be placed upon that prior to his release to inpatient treatment. All right. So
Tether is a net treatment. Tether to get.
if you're released on a PR to treatment, they're going to put a tether on you before they send you to. Got it.
I do appreciate you letting me go to treatment.
Absolutely. So in that respect, with those modifications, bound to continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Brian Brown.
Good morning, Your Honor, and good morning to your staff. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown. I believe Mr. McQueo is appearing for the Attorney General.
That's correct, Your Honor. James McWheel, appearing on behalf of the state.
Had a bench warrant for his failure to appear.
Yes. I was asking that be a set aside, Your Honor. I think that was entered when we interpreted the date as, that was maybe in January. We interpreted the date for to be an afternoon date, so we signed on it at 12, and you issued the bench warrant at 9. And it was you were unaware that Mr. Brown was in federal custody at that time, so he didn't appear. He doesn't have any capious history, and we would appreciate that being set aside because he is trying to negotiate a bond on his federal matter, which I don't represent him on that case. But I know that they're trying to do something about it. Mr. McQueo reached out to me yesterday. Unfortunately, I'm in trial. I'm being called in to do a closing argument on a murder case right now. So, but I didn't not want to appear before you, Your Honor, and actually always enjoy appearing in front of you. But notwithstanding, we have not gotten any closure or any further, and I'd be asking to adjourn this. He is in custody. There's a pending child support matter that requires addressing also, which led to this. So I didn't ask Mr. McQueo. He did send me an email. I just didn't get a chance to get back to him.
All right. I will set aside the bench warrant. I'll reinstate his previous bond in this case.
Bench warrants are serious. They represent failure to appear. Here, defense argues timing confusion and federal custody involvement. Judge Simpson sets the warrant aside. That reflects judicial discretion. Courts evaluate intent. Was this willful avoidance or logistical complication? The attorney emphasizes no history of capias, meaning no repeated skipping of court. Judges care about patterns. Reinstating bond is significant. It restores conditional freedom and trust, but it also implicitly warns, do not repeat this. The mention of federal custody complicates things. When someone is held elsewhere, coordination failures happen. Judges must account for jurisdiction overlap. Should courts require stricter verification before issuing warrants when federal custody is involved? Or is personal responsibility absolute regardless of custody status? This decision balances enforcement with fairness, a common judicial tightrope.
Thank you.
And then we need to set this for further proceedings. Did you want this set for a PCC?
Please, it's not a, you know, it's not an exam, you know, it's, yes, a
Right.
PCC would be fine.
Set a probable cause conference, okay? He's in Sanilac County, so I'm gonna need 3 weeks for the real, at least. I don't have the 8th, I have the 6th, it's probably not enough time, so I'll set it for May 15th.
Thank you, Your Honor.
May 15th, 2025, 9 a.m.
Thank you so much.
Thank you, Judge.
I'll have a visit with you, Mr. Brown.
All right. Thank you, folks.
Thank you.
Thank you. All right. Bye, Judge.
Court calls case People versus Desmond Burton.
Assistant Public Defender Chelsea Bridgefield, with Desmond Burton. Mr. Burton, please state your name.
Thank you.
Now, we are asking to adjourn today. I was able to speak with the prosecution this morning, and we're continuing plea discussion.
May 1st, 2025, 9 a.m. Bond continued. Court calls case of the People versus Mercedes Cobb.
And then on behalf of people. Good morning. Coaching.
All right, what are we doing?
At this time, we would like to set this matter for exam.
All discovery is complete. I don't know what that means. Guys use those fancy words. People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination in person, April 29th, 2025, 9 a.m. That's before me. That's before me.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case. People versus Devin, is it Gothorpe?
Assistant Public Defender Hannah Apple, here on behalf of the development. We take it to the record.
Devin Goffler, Your Honor.
Thank you.
Your Honor, asking this matter set for a preliminary exam.
Discovery is complete.
Yes.
People have their witnesses available the 29th. Sorry?
We'll do our best. Sorry to make you up.
You did. Preliminary examination in person, April 29th, 2025, 9 a.m. That's before Judge Barr.
We return to procedural rhythm. Discovery complete. Witness availability confirmed. Prelim scheduled. The repetition you're hearing across cases is not redundancy, it's structure. Preliminary examinations are gatekeeping devices. They determine whether a felony proceeds upward. Each scheduling decision sets pressure timelines. Witnesses must prepare. Prosecutors must organize. Defense must assess cross-examination strategy. Bond continues again. That consistency signals that none of these defendants have triggered new risk indicators. Prelim scheduling also sets negotiation clocks. Plea offers sometimes expire before prelim. The date itself becomes leverage. Would you schedule a prelim quickly to force the prosecution's hand, or delay it to negotiate quietly? This is courtroom chess played through calendars.
Bond continued.
Thank you.
Court calls case of the People versus Antoine Coleman. Really? She was just in the room.
I'm here.
No, I know you're here. Where's Zach and Ruley? Now, here she comes strolling up now.
Judge, I am so sorry.
No, you're not. Go ahead.
Thank you so much. This is Mr.
Coleman.
Antoine Coleman.
We've all been introduced while we were waiting for you.
Assistant Public Defender, Chinadi Carey, I can Your Honor, on behalf of Mr. Just say your name for the record already.
He did.
Yes.
Like I said, we've been formally introduced while we were waiting for you.
Your Honor, we respectfully request that this matter be set for preliminary examination, please.
Is all discovery complete?
To our knowledge, Judge. Yes.
Did the people have their witnesses available the 29th?
Going to try our best, and I just wanted to confirm my previous response that Mr. Collins had to a misdemeanor with the acceptance into a treatment court. So I want to confirm that they are not interested in deleting. They are rejecting that potential.
All right, then Judge, Mr. Coleman would like to adjourn this matter if we could, so we can look into that.
Probable cause conference will be adjourned May 1st, 2025, 9 a.m. Bond continued.
Thank you.
This exchange carries subtle tension. Defense references potential treatment court acceptance. Prosecutor clarifies that the defendant would need rejection from all potential offers before consideration. That signals conditional eligibility. Treatment courts are selective. They often require demonstrated substance abuse issues, low violent history, and compliance willingness. The defense asks for adjournment to explore that path. Judge grants it and continues bond. Again, stability. Treatment courts are alternative pathways, structured supervision instead of traditional sentencing. But eligibility isn't automatic. If a defendant qualifies for treatment court, outcomes can shift dramatically. Reduced incarceration, intensive monitoring, rehabilitation focus. Should access to treatment courts be expanded broadly, or remain selective to maintain program integrity? This adjournment isn't delay, it's opportunity exploration, and the next appearance could determine whether this case moves toward traditional prosecution or structured diversion.
Court does call the case, People versus Robert Lewis.
The people on all cases.
4, 6, 7, 8, all 8 cases.
Good morning again, Your Honor. Robert Ellman standing in for attorney of record James Michalski. In this matter on the case ending in 1-3.
And Assistant Public Defender Chinami Perry, Your Honor, on behalf of Mr. Robert Lewis on all of the other matters.
All right. Mr. Lewis, you have no problem with Mr. Ellman stepping in for Mr. Michalski today?
No, Your Honor, I do not.
All right, very good. What are we doing?
Your Honor, as far as my case, Mr. Lewis wishes to waive his preliminary examination. That's with the understanding that we are seeking a resolution of this matter. Circuit court potentially in drug court. I do have a signed waiver here.
All right. Sir, is that correct on this case that you're waiving your right to have a preliminary examination?
Yes, it is, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Ellman.
This is a decisive procedural move. By waiving the preliminary examination, Mr. Lewis gives up the opportunity to force the prosecution to present witnesses and establish probable cause in open court. That waiver sends the case directly to circuit court. Why waive? Because sometimes the defense sees the evidence and determines that probable cause will easily be met. Instead of previewing cross-examination strategy, they preserve leverage for negotiations in the higher court. Notice also the phrase global resolution. That's strategic language. When a defendant has multiple pending matters, counsel may aim to resolve everything in a single structured agreement. Circuit court offers broader sentencing flexibility, including specialty courts like drug court. Being bound over increases stakes. Felony-level consequences now dominate, but it also opens broader negotiation channels. Here's the strategic fork. Challenge early and test witnesses, or move upward and negotiate from a consolidated posture. In felony litigation, that decision can shape sentencing exposure significantly.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
May 7th at 1:30 before Judge Conlon.
May 7, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond in this case will continue.
And Your Honor, I do apologize. I should have spoken up. I didn't want to interrupt the court, but Mr. Lewis would like to weigh on all of the remaining matters as well. There is a hope for a global resolution in all of the matters.
All right. And they're all one count. Looks like they. All right, Mr. Lewis, is that all correct that you wish on the remaining matters to?
Yes, Your Honor.
All right, you understand what I said before, that that's a proceeding where people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
And you understand you'll not have that hearing proceed to circuit court.
Yes.
On all of the remaining matters, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over in each case on a single count.
Your Honor, we do acknowledge receipt of the information. We wait for reading standing. You asking the court to enter or not guilty. No, Mr. Lewis is not.
Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial in these matters will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond in all these matters will continue. Court calls the case People versus Richard Hall. And I'm gonna do.
And then on behalf of people, Your Honor.
Morning.
Christopher Quinn here on behalf of Mr. Hall.
Your name, sir?
Charles.
All right, what are we doing?
Your Honor, maybe briefly for
Oh, boy. Sure. Just starting to go downhill. All right, record should reflect that a brief bench conference.
The tone shifts noticeably here. The judge references potentially disturbing phone calls connected to the victim, even if indirectly. This is no longer routine scheduling. This is risk assessment. Defense has not yet received the recordings. The judge acknowledges that fairness requires review, but even without full evidence evaluation, the court moves cautiously. That's why we hear about adjournment and then a conditional restriction on phone privileges. When allegations of witness intimidation or improper contact arise, courts act swiftly, not because guilt is determined, but because prevention outweighs delay. Revoking or limiting phone privileges inside custody can materially affect defense preparation. Communication channels shrink, but the court must balance defendant rights with victim safety. Would you prefer judges wait for full review before imposing restrictions, or act immediately when potential threats surface? This is judicial triage, managing risk in real time while preserving procedural fairness.
My understanding is that and Mr. Quinn has not gotten a copy yet, but there are some phone calls which are rather potentially disturbing phone calls, not directly to the victim, but to a third party with references to the victim in this case. But again, Mr. Quinn, not trying to put him at a disadvantage in this, but he has not got those copies of those phone calls as of this moment. So were you asking for an adjournment of this? What were you asking?
Yeah, I'm gonna need some time to get that information and review with my client.
All right.
And decide on how we proceed.
So probable cause conference in this case will be adjourned to May 1st, 2025 at 9 a.m. I will have the defendant's bond in this matter will continue with the one condition that the defendant's phone privileges are hereby ordered revoked pending a hearing. Court calls the case of the People versus Sean Newcomb.
people.
Brian Bowling on behalf of Mr. Newcomb, Your Honor. State your name for the record, please, sir.
I actually have spelled several names in all the paperwork. I don't know what you want to do. That's how it's treated. That's how it's treated. And my name several ways in all the paperwork. You can talk about the federal jobs and in jail. I don't know what name you like to use.
What name do you go by?
I go by Whitney.
Okay. Have you ever gone by Sean Newcomb?
They have it spelled, like I said, several different ways on all the paperwork. SEAN and SHAW. And that's most of the paperwork. I have a letter from the public defender's office. The envelope has to spell SEAN. The letter inside has to spell SHAW. They have spelled many different ways. I don't know what you want to use. It's not my fault, it's your failure.
Okay, well, we'll accept that failure. And I will indicate that to the best of the court's knowledge, we'll proceed with this understanding the person I know to be, or not know to be, but is Sean Newcomb. All right.
Your Honor, based on my interaction with Mr. Newcomb yesterday at the jail and this morning in the lockup, I believe I'm required to request a competency evaluation in this matter.
Forensic evaluation will be ordered. I'll need the orders. I have those, so you'll need to supply those to me.
I'm working on it with the case calls.
All right. I'll set a competency hearing in this case for July 17th, 2025, 9 a.m. This time the defendant's bond is continued. Thank you.
Thank you, Judge.
Oh, that's it. His bond's revoked.
This is one of the most dramatic moments in the session. Bond revocation is not minor. It represents a complete shift in custody status. The abruptness suggests an in-court disruption or behavior severe enough to warrant immediate action. Judges maintain authority through order. When courtroom decorum collapses, consequences are immediate. Revoking bond removes conditional liberty. It alters negotiation leverage instantly. A defendant negotiating from custody faces different pressure than one negotiating from release. This is where courtroom conduct becomes strategic. Every word, every action in front of the bench can influence outcome. Should judges exercise immediate revocation power in response to disruption, or provide warnings first, regardless of perspective? This moment underscores a fundamental rule. Courtroom behavior directly affects liberty.
Hold it. Don't go anywhere near. We got to get somebody in here because somebody's got to clean that up. Court's going to stand in recess. Court does call the case, People versus Nolan Crawford.
Mr. Crawford, who's to my right, please state your name for the record.
Okay.
Your Honor, at this time, we would like to waive the circuit court. I believe we are seeking for you there. With no objection to item.
So the people don't have an objection to hide it, but he's waiving, and there's going to be
That's
some.
correct, Your Honor. The offer extended was a 2-year high court misdemeanor, so my understanding is that this court was not going to go to. Is that correct?
Have you seen me take one? That's what I thought. Okay, so he's waiving. Sir, you're waiving right to a preliminary examination? All right. You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, it is.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Another waiver, another bind over to circuit court. But here, notice the judge's remark, "Have you seen me take one?" That line signals judicial consistency. The judge is clarifying that plea offers are not being accepted at this stage. The defendant knowingly waives the preliminary hearing. The judge confirms understanding of probable cause standards. That repetition is intentional. The record must show comprehension. When defendants waive prelim, they are not conceding guilt. They are choosing forum. Circuit court becomes the battleground. This procedural step may seem repetitive, but each bind-over increases cumulative exposure. Felony-level proceedings escalate potential sentencing frameworks dramatically. If you were tracking this docket, you'd notice a pattern: waiver, bind-over, scheduling pretrial. That rhythm reflects system efficiency, but also how quickly cases move once probable cause is uncontested.
Your Honor, we wait for more reading. My time is standing.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 9th at 1:30 for Judge.
June 9th, 2025, 1:30, Judge Hamoud.
Yeah.
Thank you. Bond will continue. Thank you, sir. Court calls the case, People versus Harold Dennis.
72748.
Wow. You decide you're going to do something today. No, go ahead. I'm sorry. My bad.
Again, on behalf of Mr. Dennis, who's appearing to the right. Mr. Dennis, could you please state your name for the record?
Thank you, sir. All right.
Your Honor, we're simply asking for a 2-week adjournment in this case. Things had to happen outside of court. That happened yesterday. The prosecutor is now going to hopefully consider a resolution in this case. Sure, we're just asking.
Probable cause conference May 1st, 2025, 9 a.m. Bond continue. Thank you. Court does call the case of the People versus Ronald Fleming.
Testimony of the people. Stephanie Cannon, on behalf of Mr. Fleming, who is appearing by Zoom.
Yes.
Your Honor, today's the date and time to go over the competency report. I did email prosecutor and your office because our office had not received any information yet. Our APA like has an update.
I got an email this morning from somebody at the Center for Forensic Psychiatry indicating that they expect Mr. Fleming to be admitted to their facility for restoration of competency in July of this year.
July.
Yes. When he was originally found incompetent but restorable, they did indicate they had a 3 to 4 month delay on admission, which does appear to be right on track for.
What was that date you gave me? All right. Then I'll adjourn this out. Keep track of it. July 17th, 2025, 9 a.m. Then we can see what.
I'm gonna come see you this afternoon, okay?
This segment centers on competency, one of the most important safeguards in criminal law. The court references restoration to competency and psychiatric admission timelines. When a defendant is found incompetent, proceedings pause. The system cannot try or sentence someone who cannot understand the nature of proceedings or assist in their defense. The delay until July reflects restoration backlog. That's a systemic reality. Mental health facilities often operate on waiting lists. The judge directly addresses Mr. Fleming to confirm he understands the next date. That personal engagement ensures clarity. Competency rulings aren't about guilt or innocence. They're about fairness. A trial conducted without competency violates constitutional principles. Should restoration timelines be shortened to prevent prolonged detention? Or does careful psychiatric evaluation justify delay? This moment reminds us that criminal court is not only about punishment, but about procedural integrity.
Mr. Fleming, did you hear that?
July 17th.
Yeah, that's your next date, but Miss Cannon's gonna come see you soon.
Who's Miss Cannon?
Your attorney.
Right here.
Oh, okay. How you doing?
All right, thank you.
Yep.
Court calls case People versus Quincy Jones. Court calls case People versus Maxwell Lawson.
People. Mr. Lawson, can you state your name for the court?
Maxwell Lawson.
Thank you.
Your Honor, I do agree. I am asking. for
Okay,
adjournment.
where's Bishop going? He's just gonna keep walking. Bishop. All right, go ahead. I'm sorry. I told him I was gonna talk to him.
We're seeking adjournment to find out some additional information. I did find out Mr. Lawson is not eligible for one of the Wayne County treatment courts. He may or may not be a good fit for another one.
In Wayne County.
What?
In Wayne.
In Rogers, yeah, in Wayne
Okay.
County. I did email both of the 14B and Judge Fresh here because I did hear that sometimes they make exceptions, but there's a lot of considerations.
In May, right? Okay. Let's do this since you're trying. Recently, we've been trying to work through some of the Wayne County referrals, so I'm gonna go a little bit further out
Thank you, Your Honor.
on this. So let's go to the 15th of May.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, sir. May 15th, 2025, 9 a.m. Bond continues.
Here, treatment court eligibility becomes central. Defense mentions Wayne County treatment options and possible exceptions. The judge extends the timeline to May 15th, slightly further out than usual. That extension signals flexibility. Specialty courts often require screening, approval, and intercourt coordination. It's not immediate. Bond continues, maintaining stability while eligibility is explored. This is conditional optimism. If accepted into treatment court, outcomes can shift dramatically. Structured supervision instead of traditional sentencing, but note the uncertainty, may or may not be a good fit. That's selective access. Treatment courts prioritize candidates who demonstrate suitability and compliance potential. Should treatment alternatives be widely accessible or restricted to maintain program effectiveness? This adjournment represents opportunity, but not guarantee.
Thank you, Your Honor.
You're all set. Court calls case People versus Latrell McKinney Hallowell.
I will appear on behalf of Mr. McKinney Hallowell. Please state for the record.
Geraldine Hallowell.
Thank you.
Your Honor, we are asking that this matter be set for proceedings.
All discoveries complete.
To our knowledge, yes.
People have their witnesses available on the 29th.
We'll do our best, Your Honor.
Preliminary examination in person, April 29th, 2025, 9 a.m. That is before me.
And Your Honor, may I briefly address bond?
How come when people are out there addressing bond? I don't get it. You want me to lock him up?
No. Judge.
Oh,
No.
okay. No, I didn't know what she was gonna ask. I'm sorry, Mr. Hollowell. Go ahead, Ms. Acker.
Your Honor, we are asking the court to consider consensual contact with the complaining witness in this case. My understanding is that she has contacted the prosecutor's office, spoken to one of the victim advocates. I don't know the details of that, but my understanding is she's expressed that same request.
Your Honor, she has contacted her office and expressed that her right to have concerns, given contact they may have had in jail. There were calls to a number she's been contacting her office, but I haven't listened to them yet to know for sure that they're her. But I have concerns, given that those calls were there, any contact.
Got it. Okay, go ahead.
And I did speak with Senda regarding this. My understanding is the number that there's potential calls from, they believe that it was her sister that he was speaking with from the jail, which is why they're not moving forward with any type of bond violation at this point. And then that she has since contacted the prosecutor's office from the same number. So I don't think that it's outside of the realm of possibility.
Because they were sharing a cell phone?
That she's using her sister's phone.
If I could clarify this just a little bit, the calls, my intern was taking calls up until 4 or 5, and she believed those calls were to the sister. However, I have not listened to those calls. There were previous calls to the victim herself. Then after arraignment, supposedly it's to the sister. There are more calls after 4 or 5 that I have not had a chance to listen to, that the victim, at the number the victim has been calling our office and contacting our advocates with. So I have concerns that those may be the victim.
Yeah.
I'm not listening to them yet.
Got it. All right. Well, what I'm gonna do is I'm gonna deny your request at this time regarding that, and let everybody take a look at everything, and then we'll deal with it on the 29th. All right. So bond will continue. Thank you.
This final segment addresses bond modification and alleged contact with a witness. Defense requests consensual contact. The prosecutor raises concerns about jail calls possibly involving the victim. Judge Simpson denies the request, not permanently, but pending review. That is a protective ruling. When ambiguity exists about possible prohibited contact, courts lean toward caution. Notice the judge's phrasing. Let everybody take a look at everything, and then we'll deal with it on the 29th. That reflects measured restraint. No assumptions, no overreach, but no relaxation either. Across this entire docket, on it we've seen recurring themes. Adjournments as negotiation tools. Preliminary waivers escalating cases to circuit court, treatment, court exploration, competency restoration delays, bond stability versus revocation, judicial discretion balancing fairness and risk. Judge Simpson maintains procedural discipline throughout, rarely emotional, consistently structured, and responsive to risk indicators when necessary. If you found this courtroom session as revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.